plenty of time. Okay, before we deal with the jury instructions and the verdict forms, are there any other issues on behalf of Mr. Pardon at this time?
No, Your Honor.
Well, yeah.
Well, they haven't listed it.
Well,
No, I think the state's going to rest for the record out of the presence of the jury. We'd like to do it again once they come in, but for purposes of making Rule 29 motions, the state would rest for the record.
okay. Yes.
That being the case, Your Honor, would
Yeah.
you like me to make that motion at this time?
Yes, please.
Thank you. Good morning, everyone. On behalf of Mr. Pardon, we would make a motion pursuant to Rule 29. And I'd like to start off, pretty much I'm going to go in the order that the charges go. However, I would like the court to know that I am not going to, we have specifications and we also have charges. So I'm not going to repeat, for instance, I'm not going to keep repeating Rule 29 for rape, Rule 29 for kidnapping, Rule 29 for burglary.
Okay.
And so, with respect to count 1, which is aggravated murder with prior calculation and design, the jury instructions state, which of course is the law, that a person acts with prior calculation and design when, by engaging in a distinct process of reasoning, he forms a purpose to kill and plans the method he intends to use to cause death. The circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause death. And then kind of skipping to the last portion of the sentence, but acting on the spur of the moment or after momentary consideration of the purpose to cause death is not sufficient. In this particular case, I don't believe there is any evidence, circumstantial or direct, with respect to prior calculation and design. There's no evidence whatsoever that Mr. Pardon engaged in a distinct process of reasoning, that he formed a plan, and in fact, the evidence tends to show that this was not a plan, and that even if you look at the evidence most favorable to the state, I don't believe we could ever get to prior calculation and design. With respect to the other counts of murder, as well as the other counts that are in the indictment, there is absolutely no direct evidence, and I understand that circumstantial evidence and direct evidence are the same and do have equal weight. However, when we look at circumstantial evidence and we have to base that on it has to be based on some fact. The way this is, it is a fact that a homicide occurred, and what we're doing is we're going backwards from there and saying, well, because this occurred, then this had to occur. Because this occurred, this had to occur. And so even in, we took into consideration all the facts and put them in the light, giving the state that advantage, I don't believe that it is sufficient evidence to find Mr. Pardon guilty. And so I would ask the court for Rule 29 on all of the counts as well as all of the justifications. Thank you.
Okay. On behalf of the state?
Yes, Your Honor. The state believes there's sufficient evidence tending to support each element of each count and specification to overcome a Rule 29 motion, specifically as to prior calculation and design. The coroner yesterday, or deputy coroner, testified that it would take at least a minute plus of the applied pressure of the cords around the victim's neck in order to strangle her to death. He also testified about the, in addition to that, the stab wound at the base of the head, the length of time necessary to tie those cords around the ankles, the wrists, and hog tie the victim would be substantial. And throughout that process, there was a deliberation going on in the defendant's mind. Should I continue to tie this woman up? Should I continue to wrap these cords around her ankles, her wrists, her, should I hog tie her? Should I put her in the closet? Should I stab her in the back of the neck? the amount of time necessary to take this poor woman and kill her in the way she was provides more than ample prior calculation and design and purpose. And for that reason, count one would be overly sufficient based on the evidence the court heard. And at least since the felony murder counts of rape, kidnapping, aggravated robbery, and aggravated burglary all must be in the course of the murder, or while attempting the murder, or while fleeing immediately after the murder. We have the defendant in all of those instances committing the crimes of kidnapping, rape, aggravated robbery, and aggravated burglary while he's committing or fleeing from the murder itself. And the predicate offenses are proven in the same manner. So I think for that reason, the state's evidence would be sufficient for a reasonable juror to look at it and find proof beyond a reasonable doubt. For that reason, the motion should be denied.
Thank you. Any response?
Thank you, Your Honor. I would just like to respond with respect to the prior calculation and design. I believe that with prior calculation and design, and again, the state has to prove every element, not just one element, but every element. And I believe that with prior calculation and design, the state has to first prove that Mr. Pardon had a process of reasoning prior to the homicide, that he had a plan or he had a scheme to carry out a homicide, and there's been no evidence whatsoever with respect to that. In addition to that, they have to be able to show that, in a sense, he had this plan and then he executed this plan. And so the mere fact that the homicide occurred, and I think that's what the last part of that speaks to, is that acting on the spur of the moment or after momentary consideration of the purpose to cause death is not sufficient. And I think that that's an important clause, because it's not the mere fact that, you know, again, if you believe the evidence and put it in the light most favorable to the state, there simply is no showing of a process of reasoning, that there was a plan or a purpose, and that he planned out a method. And in fact, if you look at the evidence, this is not a situation where the evidence shows, for instance, this young lady was tied up, that someone brought rope, someone brought things to the scene to carry out a purpose. This kind of shows things were grabbed at the spur of the moment. So again, I would ask that the court grant a Rule 29 specifically with respect to that count.
All right, thank you. Okay, as to the issue of prior calculation and design, I mean, the instruction that the court will provide to the jurors is as stated by both parties. However, the court finds this language instructive as to whether or not there's sufficient factual evidence in the record for the jurors to consider. The circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause the death, and that no definite period of time must elapse and no particular amount of consideration must be given. The court believes that ultimately will be a factual determination on behalf of the jurors based upon the evidence that's currently in the record, whether or not based upon all the facts, whether this act occurred either as a spur-of-the-moment action or that there was some definite thought given as to how and the means and the manner in which the homicide was going to occur. So the court does believe that there is sufficient evidence in the record for reasonable minds to reach different conclusions as to prior calculation and design. Likewise, as to the other offenses, the court also finds that there is sufficient evidence in the record that each and every one of these elements, each and every one of these counts with each and every one of the elements and specifications, that there's sufficient to be given to the juror for their consideration. Again, looking in the evidence and the like, most favorable to the state. Reasonable mind cannot reach different conclusions as to proof beyond a reasonable doubt of each material element of the offense, and therefore the Rule 29 motion is overruled. All right, are there any other legal issues that we need to deal with before moving to the jury instructions and the verdict forms?
I believe so from the state standpoint.
There's not.
Okay. Okay, with respect to the jury instructions, the only changes that I made were minimal. With proof beyond a reasonable doubt, it just read most important of his own affairs. I just added his or her own affairs. I think likewise to the deliberations. I think it indicates that I could just added her. And then made the changes that Ms. Roush suggested, which was just grammatical. Beyond that, it's what was provided yesterday. So anything else with respect to the jury instructions on behalf of the state?
No, Your Honor, the state satisfied with the 24-page instructions, having gone through each page and each offense element, spec, and general instructions.
Okay. Any objections to the instructions?
Judge, I just wanted the identification as Anthony Pardon, perpetrator of, I don't think we have an identification instruction in here at all.
Caused the death of in the course of the offense or throughout. Certainly, the evidence doesn't prove that the defendant did it, and that would be a failure of proof.
Mr. Thomas, I'm assuming that
It's not like we have a photo ID or some kind of ID of that nature that needs to.
Judge, I think there's a standard OJI instruction on identification, if that's the issue. I believe that was issued in this case.
you know, but I've included it in several. I'm trying to find the OJI instruction.
The only one I'm familiar with, Your Honor, is one when a victim may testify and identify the defendant even in court pursuant to photo array, and there's an instruction dealing with potential frailties of eyewitness identification, and that's the only thing that I can think of, and that's not present in this case. I don't know if there's another one that Mr. Thomas has in mind.
The one that I'm thinking of, and that's what I'm trying to find, because I want to make sure that we're talking about the same thing, is that it says something along the lines that the state has to prove each and every element, which includes the identification of the defendant.
That's correct.
Okay. This is the language that has been used before, so just let me know if this is what you're referencing, Mr. Thomas, and then the state if you're objecting to this language. One of the issues in this case is that the identification of the defendant as the perpetrator of the crime. The state must prove identity beyond a reasonable doubt. It's not essential that the witness be free from doubt as to the correctness of their statement. However, you, the jury, must be satisfied beyond a reasonable doubt of the accuracy of the identification of the defendant before you may convict him or her. If you're not convinced beyond a reasonable doubt that the defendant was the person who committed the crime, you must find the defendant not guilty. The value of the identification testimony depends on the opportunity the witness had to observe the offender at the time of the offense and to make a reliable identification later. You should consider whether the witness had the capacity and adequate opportunity to observe the offender. You may take into account both the strength of the identification and the circumstances under which the identification was made. Finally, you must consider the credibility of each identification witness in the same way as any other witness. Decide whether the witness is truthful and consider whether the witness had the capacity and the opportunity to make a reliable observation. Is that what you're referencing?
That is correct, Your Honor.
Okay. On behalf of the state?
Well, I think, Your Honor, as I stated previously, about half of that doesn't apply to what we have in evidence in this case. I think the first half probably does, but the second half would not.
Okay.
And if I could, maybe the court could print it out and we could both look at it and then agree or disagree on what parts of it should be given.
Okay.
And Judge, I don't have a problem having that printed out, but I think that's a instruction that applies. I think that, well, Judge, that we can look at it and then we can go through the arguments.
Okay. After that paragraph or before that paragraph?
Before it.
Yes, in between where expert witnesses end and
You should.
should not decide any issue of fact on the number of witnesses. So right in between there.
Okay. And all or part?
State didn't object to all of them, Your Honor.
All right. Anything else on behalf of the defendant with respect to the jury instructions?
No, Your Honor. Thank you.
Okay. All right. Verdict forms.
State reviewed the verdict forms that the court submitted to us last night and appeared to be in order to make.
Thank you. On behalf of the defendant?
No, Your Honor, we have an opportunity to review verdict forms and we find them the evidence.
Okay.
And more than that, Judge.
All right. Okay, give me a minute to get my secretary to make that one change to the jury instructions. If the jurors are all here, I know some of them had some issues finding parking. We'll bring them in, again, allow the state to formally rest in front of the jurors. I'll ask if there's anything on behalf of Mr. Pardon. You can rest at that time. And then I'll let the jurors know that we're moving to closing argument.
Your Honor, I have a PowerPoint for first close, so could we put the screen down and make sure it works before my luck with technology?
That's wise.
Judge, I would just like to add that we will renew our Rule 29. We want to correctly, we will renew our Rule 29 after we rest.
Okay.
Understanding that we want to get our exhibits and renew
I think we amended our exhibits last night, didn't we?
Yes,
So, are we good?
yes. With respect to the exhibits, yeah. And just making sure that there's no objections to what's going to be used on the PowerPoint. I don't know if you had any discussions. My assumption that it shouldn't be, but okay, you just want to make sure that there's no
Anything
objection.
that's out there has been admitted